that discriminatory treatment is itself an injury under our precedents in Article 3, certainly, and Havens Realty. The discriminatory treatment here, I think Mr. Unikowski is saying, would have occurred at the hotel or inn, and that there was no discrimination in the information provided because everyone was provided the same information. I just want to give you an opportunity to respond to that.
Yes, thank you, Your Honor. I think that's wrong for the reasons Ms. Ross said. Under 12182, places of public accommodation cannot discriminate in the provision of services. So it's not just in access to their building. The service itself has to be provided in a way that allows people with disabilities to use it in the same way as non-disabled people. I also think this argument, when it's framed that way, really is a merits question, and under Steele Co. isn't part of the standing inquiry. I think under Steele Co. and Lexmark, and if you combine those with TransUnion and Spokio, the court assumes as valid Ms. Laufer's cause of action here. So you assume that the allegations in her complaint state a claim of unlawful discrimination under 12182, and then you also assume that Congress conferred a cause of action to her. And then the question is, did Congress act within its constitutional authority when it provided a cause of action here?
I think Mr. Unikowski is saying, particularly in the briefs, this is an Allen versus Wright kind of case, not a Havens Realty kind of case. And the distinction between those two cases, Allen versus Wright, as you know, someone in Hawaii can't complain about discrimination that's occurring in Maine. Havens Realty, you actually personally experience the discrimination yourself when you're, as then Judge Barrett said in Casillas, when you're lied to because of your race. So why isn't this case more like what Allen versus Wright described there?
The plaintiffs in Allen v. Wright were challenging the IRS's failure to enforce a provision of the Internal Revenue Code that required it to withhold tax-exempt status from discriminatory schools. The plaintiffs in that case had no private right to the IRS complying with the law. They were seeking to enforce a public right. And in those circumstances, they had to show that they were personally injured by the IRS's noncompliance.
But I wonder whether there isn't